High Court. Let's take you there live.
The 12th for further trial. As a result of me being told, jokingly, let's accept, by Mr. Mbaromba that they are only involved in the bail application, myself and Mr. Doven have been phoning around to find out who is doing the trial. And we found out from Mr. Sandon, who's the person in charge of the roles, that Mr. Telva and Mr. Mbaromba are doing the trial. Fine, that's sorted. But if that trial does not continue next week, in the face of the state being compelled to file amended further particulars, that happened in March already, that is another seriously unnecessary delay.
Mr. Price, just one moment. The main case was supposed to have proceeded on was it Tuesday this week? No. The main case was supposed to have proceeded, yes. And the only reason that did not happen is because of this application.
That's true.
I have to entertain this application, and because of that, I had to postpone the main case to Monday, and that was with the hope and expectation that by Friday we would have wrapped up this case so that the main case proceeds on Monday. Yes. Now you are telling me that your witness that would have enabled me possibly to finalize this case this week, your witness will not be there. He will only be there on Monday. It's a she. She will only be there on Monday, which then means that it's well nigh impossible for me to wrap up this case in the course of this week so as to enable the main case to proceed on Monday. Because if you are only calling your witness on Monday, then presumably thereafter you close your case, the state opens this case, I don't know how long it will take, then that means, as a matter of certainty, that the main case will further be delayed because it will not commence before we finish these proceedings. I don't know if I'm missing anything.
Well, certainly you and I don't agree on one thing, and that is that there's no reason at all why the main case can't continue pending the result of this case.
I'm not sure I'm with you.
Well, let's say, for example, it happens that, let me make one thing very clear, because I don't think they have got through. We only just heard now from this witness that she's only coming on Monday. So I don't think we can be blamed for that at all.
Well, we're surprised that that's debatable. This is your witness. You knew you were going to call this lady as your witness, and I would have expected that you would have made whatever arrangements need to be made to talk to your witness and to agree with her that you will call her on such and such a day. I haven't heard you saying that you've done that. If I understood you correctly yesterday, you said it's your attorney, Mr. Doberman, who had spoken to her, and I haven't even heard you saying that she had told her to avail herself to testify for you in the course of this week. I haven't heard you say that.
There was no need for that because the prosecution told us, I think on Wednesday already, that she would be here on Friday. They told us, and I think Mr. Ntewa will
you say that only happened on Wednesday?
That we heard that she would be here on Friday.
That's the whole point, Mr. Doberman. I'm sorry, Mr. Price. It's your witness. You knew you were commencing with your case on Tuesday. I can't understand why you need to hear from somebody else that your own witness will be here on a particular day. I thought if you had a witness you want to call, you consult with your witness, you arrange with your witness as to when you want to call her. You can't wait to hear from someone else as to when your witness will come. That's the part I don't understand.
That witness is a police officer and a state witness and lives in Kimberley. I don't know, my Lord, can I just state, I'm not going to debate with your Lordship this issue anymore. We've debated it before.
I have no intention of doing that either. So what is the way forward?
I will leave it for argument if necessary.
Yes.
My point is this. If this matter, if this lady testifies on Friday, not on Friday, Monday the 12th, and she's completed and I close my case, the state calls Plykies or whoever they want to call, that's completed. Why can't the matter continue, the trial continue on Tuesday the 13th? We would insist that it continues on Tuesday the 13th because a decision by this court on whether or not we're going to get bail is irrelevant to the main trial. And if the main trial cannot continue, through the fault of the state that they are not ready after all this time to continue, that is a crucial issue in favor of the applicant, and it just confirms wholeheartedly our claim that the state are playing games and are delaying this case unnecessarily.
I'm not sure that I'm with you, Mr. Price. You'll remember that your own application has prayer A, which deals with an inquiry into delays as to whether there's been an unreasonable delay. So it's not purely a bail application. It also has prayer A, which you are still going to convince me that this court can entertain. And then there's a bail application. Now, if you have those two prayers and you are still persisting that this court decides, of course, that's what your notice of motion says. Then if it was possible for the main case not to await the outcome of these proceedings but to proceed, then I'm not sure I understand why you indicated that the main case could not commence and proceed this week. If it's possible for it to proceed next week without awaiting the outcome of these proceedings, then I'm not sure why did it not proceed this week, if that is your stance.
Because the accused exercised his constitutional rights to apply for bail. The dates that were set down by the Judge President, Mr. Justice Fonseca. And it was he who suggested, and we didn't argue, that this matter, the bail application, should be heard in this first week. That had nothing to do with us. But be that as it may, how can you be critical of the applicant bringing a bail application which the Constitution entitles him to do?
Are you asking me a question, Mr. Price?
It's a rhetorical question, my Lord.
Yes, I'm sure it is.
My Lord, I don't appreciate the manner that you're talking to me. I've treated you with respect.
Mr. Price?
My Lord, please don't treat
No, Mr. Price, please treat the court with respect.
My Lord, you've just made
Please
a comment.
treat the court with
I will
respect.
treat you with respect, my
Yeah,
Lord.
please do.
You've just made a comment that I don't
It's
like.
for the decorum of the court. It's very important that you treat the court with respect. All I'm saying is, if your view is that the main trial should not await the outcome of these proceedings, if that is your view, then I'm asking myself, why then did the main trial not proceed this week if it did not have to await these proceedings? The main trial, let me finish, please.
Sorry.
The main trial was postponed for next week with the expectation and hope that these proceedings would be finished and finalized this week. Now that has not happened. So all I'm saying is, if these proceedings will be proceeding next week, and the reason the main trial could not proceed this week is because of these proceedings, I'm trying to understand how, when these proceedings are still continuing next week, the main trial can also continue next week. I don't get that.
My Lord, let me see if I can put it differently. I'm saying, and I think the authority is on my side on this, I am saying that your decision at the end of the day on whether this applicant gets bail or not it plays very little, if any, role on the actual criminal trial. Where it is important, but not important to the extent that the judgment should be given before the main trial continues, is these incessant and constant delays. And what I'm saying to your Lordship, let's say, for example, we finish everything on the 11th and your Lordship makes a judgment on the 11th. Either way. The 12th, this case can continue. If your Lordship says on the 11th, I want heads of argument or I need a bit of time, the main case can continue. Because your judgment, your decision on whether or not to go in our favor plays very little, if any, role on the leading of evidence in a criminal trial. And if we wait for that, and if we do not continue with the criminal trial, it's simply another delay. Because, my Lord, let's look at what judgments you can give. In terms of 342A, you've got those 3A, 3B, 3C, 3D. None of those are competent to you in this case. You can't refuse the prosecutor, strike it off the rod, etc. So, but that Act says any decision, you can grant any order that will assist or will undermine the prejudice that the accused is suffering, the applicant is suffering. That includes granting bail. The bail application, same thing. Let's say, for example, my lord, you find that this is not a 342A and you consider this on bail, and let's say you refuse bail on Monday afternoon. Why can't the main case continue? Let's take it one step further. Let's say you say on Monday afternoon, I've heard some new stuff now, I want heads, or I can't give you judgment until Wednesday. Nothing can and will or should stop the continuation of the criminal trial.
Mr. Price, the main trial is set down to proceed on Monday. Set down for Monday.
That's correct.
Now we know that the main trial cannot start on Monday because you will still be here and the state will still be here dealing with this application.
Yes.
It is on that basis that I said, then surely on Monday the main trial cannot proceed.
No, it can't proceed on Monday, but it can proceed on Tuesday.
No, you don't know that this case, this matter will be finished on Tuesday. You don't know that. You are still leading your own case, and the state will still lead its own case. We don't even know how long you will take in cross-examining the witness. Let me finish, please, Mr. President. Yes, let me finish, please. Please. You don't know how long the witness for the defense, for the respondent, will testify. You don't know how long you'll cross-examine him. So you cannot be in a position to say on Tuesday you would be ready to proceed with the main trial. That's the whole point I was making.
You can't find, I can't. But what I'm trying to say to you is, we don't need to have a result in this case before the main trial can continue. Whether the main trial, starts on Wednesday or Thursday or Friday, it's not dependent, that's my argument, it's not dependent on the completion of this hearing.
The main trial, Mr. Price, cannot commence when you and the state are still dealing with this application. That is what I'm saying. You will be leading your witness. We don't even know how long the state will take in cross-examining him. The state will open its own case. You don't know how long that will be. And before that finishes, the main case cannot commence. That is all I'm saying. And I thought it's obvious.
No, I fully agree on that.
Yes.
There's no dispute between us there. All I'm saying to you, and I'm going to repeat it and repeat it just once, the continuation of the main trial is not dependent, and let me use this word completion in a more narrow sense, is not dependent on this judgment, your Lordship having given a judgment in this case. In other words, let's say all the evidence is finished. Let's say we've addressed you, and let's say your Lordship needs a bit of time. Let's say we finish on Tuesday. Let's say, listen, I'm going to give judgment on Friday. Nothing stands in the way of the criminal trials to continue on Wednesday and Thursday. That's what I'm saying, my Lord. I'm not going to address you.
Mr. Price, just on one aspect. Your prayer won in your notes of motion.
Yes.
If you convince me in your argument that I should deal with prayer one. Now, my dealing with prayer one, what effect does it have on the main case?
On the main case?
Yes.
Nothing. Nothing whatsoever.
Right.
Because you cannot give the order in 342A3A because the matter because they've pleaded. That goes the same with 3B, goes the same with 3C. 3D is the only one that you possibly could do of those mentioned in 342A subsection 3, which says that you can order the state to close this case, and that would be the end of the matter. But even that one is not really available to you. But what I'm relying on, my Lord, is 342A, the wording that says any order including, and we submit, you may disagree with us on that, my Lord, but we submit any order includes. Remember, what 342A wants you to do is deal with the prejudice. The minute you find there's prejudice, you must deal with it. And then you can make a number of orders, my Lord. And the order we're going to ask you to make, because of the overlap, is if you find that it's unreasonable today, and if you find that we've got merit in what we say, is to make an order that the appellant be granted bail, the applicant be granted bail. But you can also make an order, for example, my Lord, saying you will continue this trial. If this trial is again delayed unnecessarily without good reason by the prosecution, we can approach you again on the same papers. You can make such an order as well. The orders you can make, my Lord, are fairly wide. So that's why I say 342A is important. I accept you can't make a 3A, 3B, 3C or 3D order, but I'm relying on the words any order which would alleviate the prejudices.
Well, I've already indicated, Mr. Price, that you'll need to address me on that after you let all your evidence, and maybe let's leave it for that stage.
Yes,
now let's deal with the stage where we are right now. Now we're in a position where you don't have your witness.
Yes, ma'am.
And where the state has indicated that it prefers to deal with this case after your case has been closed. And your witness is not here today, which is Thursday. We had initially hoped that he would be here tomorrow and would proceed with him.
That's correct.
You now tell me that he will not be here tomorrow either. He can only be here on Monday. So which means, effectively, that these proceedings have to be postponed for Monday.
My Lord, yesterday when we briefly discussed the same issue, I pointed out, and I'm going to point it out again, that there cannot be and will not be any prejudice whatsoever to the respondent, the calling of this witness, because the calling of this witness, I've indicated to you, is going to be on very narrow grounds that the prosecutor, with all possibilities, agrees with. Nothing the witness is going to say, and the prosecutor knows what the witness is going to say, is going to in any way prejudice his case or undermine any of his submissions thus far. Your Lordship he came up and he said he doesn't want to, he wants to wait. Your Lordship said, if I can recall correctly, that you cannot force him to call his witness. That is not correct. You can force him to call his witness. If it's in the interest of justice that he call plighties, and if we, subject to his right to reopen his case, if the witness we are calling says anything prejudicial, is the way to go, Your Lord. I'm again asking you to order the state, as is your right in terms of applications of this nature, to present that evidence now. Thank you, My Lord. That's all.
Mr. Ndelo?
Yeah, my Lord. I would understand what my friend is submitting to my Lord, that if it is in the interest of justice, she would prefer me to open the state case in these proceedings. But does my opening of my case really serve the interest of justice in this case? Because even if I happen to open and call Mr. Paitis to the witness stand, the case still is going to be rolled over till Monday. It does not serve any purpose.
But then, would it not have effect that on Monday the only thing that would happen would be for the witness to testify, and would have disposed of pledges if that will not be prejudicial to the state? You see, Mr. Ndelo, I've got to safeguard two interests here. The interest of the applicant, the interest of the state, all of which should amount to the interest of justice. I don't want to prejudice any party. But apropos what you are saying, that it would serve no purpose to call your witness simply because on Monday we still have to be here. But if it will not be prejudicial to you and you are agreeable to it, then we would have at least been able to utilize court time both today and tomorrow. But I repeat, ordinarily, a party that has commenced with its case proceeds with it to a finish, and then and only then the other party that responds opens its case and proceed with it. Now, I don't wish to prejudice you if the non-observance of that normal procedure can be prejudicial to the respondent. I don't want to do that. So, but I'm leaving it to address me on that, on what a proposal has been made by the applicant. Now, what is your response to that proposal?
And I want to also reiterate that in this position we are respondents.
Yes.
We are responding to the case that has been put before you, your lordship. We are replying on that. We don't know what we are replying on. They are saying they are pulling a witness that will throw another light to this, to this proceedings, and also to the state case as a whole. How are we going to deal with that? If we call our witness now, what are we going to lead him on? We lead our witness according to the case that he has to answer. We are going to be prejudice. Leading evidence, we don't know what we are relying on. Our case is not general. We don't want to waste the court's time. We are dealing with the issues that are before this court.
Yes.
As a court.
Well, the proposal was that if after the witness is called on Monday,
yes, sir,
you feel there are things that you still need to cover,
yes, sir,
you may reopen your case that would have closed to cover those. It may be an untidy process, and I'm not going to force you to it.
yes, sir.
Only if you say the state will not be prejudiced, and you are prepared to go with that start stop without being prejudiced. It's only in that case that I may possibly countenance the procedure that is being proposed, which in my view is untidy, but which in the interest of preserving time I could countenance, but not at the expense of prejudicing any of the parties. If you want time to maybe discuss
Yes,
with your co-counsel and you take a stance as to what your submission should be on this aspect, I can take a short adjournment to allow you to properly consider in consultation with your co-counsel before you address me on this aspect.
Understand, madam. Please, we can.
Do require time.
Please, madam. Then we can see what will happen.
Yes. Okay. I won't prescribe any particular time within which to do it. Once you are ready, let me know.
I will.
Father Jones.
All right.